Hi, it's Lisa with Family Matters Law Group. I'm one of the attorneys, and this video is intended to give you some basic information about how child support works in Florida. So child support in Florida is essentially an algebra formula. It's a calculation that takes into consideration both parents' incomes, the cost of child care, and the cost of health care, both for the children and for the parents. All of those numbers go into a formula, and it tells us who owes whom what amount of money based on the numbers that went into the formula. Now, those numbers may go up or down at that point depending upon the number of court-ordered overnights that each parent has with the child. So court-ordered overnights are not applicable to cases where mom and dad have not been married and you've never been to court previously about the child. If that is your situation, then the number of overnights will be calculated very likely at zero, regardless of what actually has been happening between the two parties or the two parents leading up to the calculation of child support. So once a child support order is requested through the courts are allowed to go backwards for either 24 months until the time that the parents last lived together. Which means it's whichever one is shorter, not whichever one is longer. So if you lived together 3 months ago, the courts are only going to be able to go back to that date. If you live together, if you haven't ever lived together, then the courts can go back for 24 months or obviously until the birth of the child. In terms of modification of child support is always modifiable. At any point in time in the future, if any of those numbers that originally went into the formula, mom's income, dad's income, healthcare cost, child care cost, or the number of overnights, if any of those numbers change and it would result in a significant difference for child support, then the child support can be modified at any point in time in the future. So what happens when you have a child support order in place and now you're considering modification, but you're not really sure if people's incomes have changed, puts us in a little bit of a predicament. So if we're not really sure whether the incomes have changed or whether the result would be significant enough to warrant a child support modification, the only thing we can do typically is to file the child support modification and engage in discovery. See if we can gather the information and do the assessment to figure out what the numbers will be. If you have an idea of what everyone's incomes are, then we are able to get a rough estimate of what child support would be moving forward based upon those ideas. This makes free consultations for child support modifications a little bit difficult, and our office tends to shy away from doing them because it really puts us in a predicament to figure out whether or not a person is going to be able to qualify for a child support modification without having all of the information. For the initial establishment of child support, it's a lot more clear and easier to give a consultation on in terms of whether it makes sense for you to move forward with filing for an initial case of child support. So again, child support is based on a formula in Florida. Child support is not waivable by either parent, meaning we're not allowed to say that we're not going to pay it or contract out of it. The numbers that go into the formula can be manipulated and played with a little bit, but whatever comes out of the formula, it's rather set in the state in terms of who's going to pay what. And child support can always be modified in the future in the event that any of those numbers change. In terms of a modification, you can only go from the date that you're filing for the modification forward. You cannot go backwards on those. So the only time that child support goes backwards is from the time you initially get child support ordered. The very first time, we can go backwards up to 24 months. Hopefully all of this made sense. It can be a little bit confusing. If you need more information, would like clarification, or feel like you could benefit from speaking with one of our attorneys, get in touch. We're happy to help and provide that free consultation.